Thank you, Norman, for this really fantastic overview of the LLMC and the global limitation of liability, and for giving the introduction actually into the particular liability regimes and their application in this sphere of limitation of liability. As Norman said before, LLMC is just about the limitation of liability, and it does not contain rules on liability. So we have a whole spectrum of international conventions regulating liability, and some of those conventions contains also special rules on limitation of liability. Some of those conventions are actually regulating extra-contractual liability, and the other contractual, for example, carriage of passengers by sea, carriage of goods by sea, as it was pointed by Norman previously, and those extra-contractual liabilities, for example, COC convention, which is going to be covered by ANTE later on, then damage caused by HNS substances, which is not in force yet, but it was also mentioned, and nuclear damage is just also not in force. I will focus on the passengers because I think it's the most complex one, and the question was already posed, so I will go with that one. Let's for start see what we have at the international level. There are the whole set of conventions or conventions and protocols. The first one is the Athens Convention of 1974, which is in force in 25 states. So we cannot say that it's not important anymore. On that convention, the first protocol was brought in 1976. That was the SDR protocol, introducing the special drawing right as a unit to account as a unit of to measure the limitation of liability. And then in 1990, the third protocol was brought. That protocol never entered into force, but it is important for our story because Croatian Maritime Code is actually aligned with those limits contained in the protocol of 1990. And the last one, protocol of 2002, is the most important one for us, at least for us in Europe, because you will see that the European Union actually acceded to this IMO convention, which is actually the first IMO convention acceded by the European Union. At the European level, apart from this accession to the convention, a regulation was adopted in 2009, and the reason for adopting this convention was actually not entered the convention, the protocol of 2002 never entered into force, and the European Union was really keen on enhancing passengers' rights, and so what they decided to adopt this regulation and to actually incorporate not all, but majority of provisions of the Athens Convention into this regulation. And it was prescribed in this regulation that this regulation will enter into force if not before the Athens Conventions entered into force, then on 31st December of 2012. And this regulation is directly applicable in all member states from this state. Apart from incorporating these provisions of the Athens Convention, what was done with this regulation, it also incorporated and made binding parts of the IMO guidelines. This is something that I have skipped because we are running out of time, but it's actually also very important for explaining limitation of liability in this context, because this is the instrument that was brought in order to supervene the obstacle for not entering into force of the convention. So the insurance market was not able to cover all the risks that were that they had to cover, and then this IMO reservation and guidelines were introduced. I will explain them a bit later. And the Croatian Maritime Code, as I have said, was and is aligned with the Athens Convention of '74, but together with protocols of 1976 and 1990. So we have in Croatia actually 3 different regimes when we talk about the limitation of liability for those damages. I will skip the scope of application and I will go to the provisions on limitation of liability, maybe come later to the scope. So, as I said, we have 3 different layers. The first one is the PAL Convention of '74, which is not important for Croatia because we have denounced that convention, namely when the country ratifies the PAL Convention of 2002, it has to denounce the 1974 convention, which is quite smart solution because we don't have this situation as we have with LLMC. The limitation prescribed with this convention is 46.666 SDRs per passenger per carriage. Croatian Maritime Code, which was aligned with the 1990 protocol, has significantly higher limits. It's 175 SDRs per passenger per carriage. And the third one is the PAL Convention of 2002, together the same as the regulation, and the limit contained in that convention is 4,000 SDRs per passengers per each distinct occasion. But this is only one set of rules, namely this is only for those damages that are caused by non-shipping incidents. It means if the passengers, I don't know, slips near to the swimming pool or down the stairs, falls down the stairs, and so on. So this is those limitations are prescribed for such occasions. And what is new in this PAL Convention 2002 and the regulation is the compulsory insurance. Compulsory insurance, which may not be less than 2,000 and 50,000 SDRs per passenger per each distinct occasion. So if we take a look at the first PAL and this protocol or PAL 2002, we can see that not only those limits are significantly raised, but also criteria has changed. In the first one, we had per passenger per carriage, and here we have per passenger on each distinct occasion. So it means if we have a passengers with a really bad luck, who has sustained several damages during the voyages, he will be able to get a compensation 2 or 3 times as much with this help as the risk. The other set of rules is prescribed for damages that are caused by the shipping incident. And the shipping incident is defined by the convention as a shipwreck, collision, stranding of the ship, explosion, or fire in the ship, and defect in the ship. In the PAL Convention of 2002, capsizing is added, and here we have some different rules. First and second line are actually the same, but in the PAL Convention of 2002, there is two-tier limitation of liability introduced. In the first tier, there is a strict liability for damage up to 2,000 and 50,000 STRs per passenger on each distinct occasion. And in the second tier, we have presumed liability for damages up to 4,000 euros. And if you take a look at this first limit, it's not actually the limit. We can say it's a demarcation between between the first tier and the second tier of liability. And this first tier, it's actually the same amount that is compulsory, that has to be covered by the compulsory insurance. Sorry, I think I've skipped something. Yeah. But this is something that's described in the convention. And a part of that, we also have the opt-out clause, which is allowing states to regulate by the specific provision of the national law the limit of liability. But this limit of liability may be only higher than one prescribed by the convention, or they can also prescribe unlimited liability. Now, why? The reason for adopting a convention is usually we say it's uniformity. And if you enter such a clause into the convention, you don't have the uniformity. But it was necessary to introduce such a provision because it was impossible to reach the consensus upon the question of limitation of liability. Namely, there was a group of countries that thought that there should not be a limitation of liability for damages caused by death of and personal injury of passengers, because the life is a high value that is protected by the Constitution, and that in that case, the carrier should not be able to limit the liability. On the other side, there was a whole spectrum of countries, developing countries mainly, who argues that there should be a limitation on liability, and that even the one from the first PAL Convention was good enough. So this opt-out clause was the result of this really tough negotiations. And another thing that is possible, the carrier and the passenger can agree upon the limitation of liability. They may agree expressly and in writing, but they may agree only to raise those limits. So this cannot be on lowering, so the passenger is protected, and it may be only done in his favor. Now we are coming to the question of the relationship between special limitation of liability and global limitation of liability, and this is what actually there is asked. And here we have two different solutions, one contained in the PAL Convention of 2002, and the other one is contained in the regulation. If you remember at the beginning of my presentation, I told you that not all provisions of the PAL Convention were introduced. So the one that was not introduced is Article 19 of PAL Convention. And this Article 19 says, this convention shall not modify the rights or duties of the carrier, the performing carrier, and their servants or agents provided for in international conventions relating to the limitation of liability of owners of seagoing vessels. So they are free to use their privilege to limit liability under global limitation of liability under LLMC, but not only LLMC 76 and 96, but we have heard there is the one of 24 and 57. And the European Union did not like that because they wanted, as I said, to protect the passengers. So they said, no, we're not going to take that provision. We're going to modify it. And in the Article 5 of the Athens Regulation, it's prescribed that this regulation shall not modify the rights or duties of the carrier or performing carrier. Those are persons who may invoke liability under national legislation implementing International Convention on Limitation of Liability of 1976, as amended by the Protocol of 96, including any future amendments thereto. So what they said you can invoke global limitation of liability, but only the one that is the most stringent one for the carrier or for the owner. Croatian Maritime Code does not contain provision on the relation between the special limitation of liability and global limitation of liability, even though there are both, and the Maritime Code, Croatian Maritime Code, is aligned with LLMC as amended together with those limits that were tacitly but approved by the tacit acceptance. This is like legal framework that Norman has explained. So if we take a look at the states that are parties to this convention, we can see that there are still some parties, some EU member states that are parties of Convention of 24 and 57 and 76 and obviously 96. Now the question is, I will skip this and yeah. Now the question is how to combine those special and global limitation of liability. The first question is, which provisions should prevail? Is it the Athens Convention, since the European Union actually acceded to the Athens Convention, or is it the Athens Regulation? And the next question is the Article 5 of the Athens Regulation, which is introducing this modified right to invoke the global limitation of liability. Is it contrary to the Athens Convention? The Athens Convention is binding for EU member states. It is actually above the regulations. However, the European Court of Justice gave the explanation when those provisions contained in the international conventions are to be above when we have to apply them. And it says that the provision of an international agreement is directly applicable when contains a clear, precise, and unconditional obligation, which is not subject in its implementation or effect to the adoption of any subsequent measure. So the question is this Article 19 clear, precise, and unconditional? And it is not, because it says that the ship owner may invoke the carrier, may invoke the national or international rules which are applicable in this case. So actually, the European Union, what they did, they actually, when we say that it used the opt-out clause because it said you may invoke global limitation of liability, but only those that are very strict. So very strict. Well, again, you will see that they're not so strict. Namely, if we go back and take a look a bit, how do we stand with maths? The LLMC 7696, which is the same as the Croatian Maritime Code, says that in respect of claims arising on any distinct occasion, the ship owner will be may invoke liability in the amount of 175,000 of units of account, multiplied by the number of passengers which the ship is authorized to carry. And in case on a huge serious incident with a huge cruise ship with capacity of 6,000 passengers, those are the biggest one, a limitation would be 1 million SDRs per ship. And that is actually, if we divide that on passengers, that would be less than 50% of the amount that was provided by the PAL convention. When we in Croatia, in Croatian court, on the Croatian court, there was one case when the court did not how to combine those two limitations. He said, yes, there is a special limitation of liability, but damages are bigger. Only one passenger sustains damage. And the court says, yes, but those damages are higher than the limits prescribed per passenger. And, you know, there is a global limitation of liability, and this passenger, he is the weaker party, and he should be awarded the damages in full. So the court actually totally ignored the fact that invoking limitation of liability is the privilege of the owner, the privilege of the carrier, and not something that the court can invoke or the passenger can invoke. The things are becoming more serious if we take a look at the LLMC 76, and as Norman said, Croatia is still party to the LLMC 76. And if we calculate, the numbers are really low. Per passenger, it would be about 5,000 euros if all passengers sustained damage. It would be only 1% of the amount provided by the Athens Convention of 2002. And I think this should be alarm, and we should really think, and we should denounce the convention. Here, apart from the cap per passenger, we also have an overall cap per ship, so but not exceeding 25 million units of account. And this convention was brought in 1976, and the size of ships at that time and size of ships nowadays is hugely different. Okay, I'm quite running out of time, yeah. So the coexistence of those global and special regimes is there. It's the privilege of the carrier or the ship owner to invoke that, and it actually brings some balance in this relation. On one side, the ship owner, on the other side of the passenger. I have mentioned before IMO guidelines. Do we have time to go through that? Not really. Okay, then I will just in two sentences say that this limitation prescribed by the IMO guidelines actually can limit further the limitations set by Athens Convention, and this is actually quite, well, not very nice for passengers, but on the other side, they are compensated for the for some damages that they would not be compensated before. And I will stop here because those other things like losing right to limit liability is the same as Norman explained, and amendments of those limits can be done through the tacit acceptance procedure. Okay, thank you very much for your